So I have some big news for you. The Supreme Court just issued their decision in the U.S. v. Rahimi case. This is a case that we've all been waiting for. It is the next in line of big 2A cases where the Supreme Court is evaluating some federal laws, specifically here 922 G8, which deals with the domestic violence restraining order restrictions and restrictions on someone subject to those restraining orders being in possession of firearms and ammunition. This was not a good fact pattern for us, and ultimately we got not necessarily a great decision today from the Supreme Court. It is an 8-1 decision in favor of the federal government against Mr. Rahimi. The 8 judges exclude essentially Justice Thomas. Justice Thomas is the only one dissenting from this opinion, so he is the one dissenter. So let's take a look at this. It is authored by Chief Justice Roberts, so that kind of signals to you where this is going. He delivered the opinion to the court. It is joined by Alito, Sotomayor, Kagan, Gorsuch, Kavanaugh, Barrett, and then Justice Jackson. Now, they are all agreeing with the ultimate resolution or outcome of the case, but there are a bunch of concurrences in this opinion where everybody is essentially coming to the some of the understanding that Mr. Rahimi was, his Second Amendment rights were not violated as applied to him specifically because of 922 G8. And some of these concurrences are coming to that from a different angle. So that's why you have a bunch of different concurrences. Some of those are coming from Kagan and Sotomayor. They wrote their own concurrence. Gorsuch, Kavanaugh, Barrett wrote a concurrence as well. And then Justice Jackson filed a concurrence as well. So there's a bunch of different concurrences in this, which essentially is saying, hey, we came to the decision. Ultimately, it's an 8-1, but we're coming to this through a different approach. So let's take a look a little bit at this. What I gathered from a quick glance at this, and obviously I'm going to put out a more comprehensive video down the road because this is going to have huge implications for the 2A application, specifically because the way that this is written already, I can see that there's going to be some language, of course, where the anti-gun side is going to latch on to some of this language, some of this verbiage from Justice Roberts, and try to use it to justify various restrictions. Now, keep in mind, I think most of this decision is specifically relating to as-applied challenges to Mr. Rahimi instead of a facial challenge to the constitutional aspect of 922 G8 at large. So they talk a lot about as-applied to Mr. Rahimi, and that's important. But here's the holding. It said, held, when an individual has been found by a court to pose a credible threat to the physical safety of another, the individual may be temporarily disarmed consistent with the Second Amendment. Since the founding, the nation's firearms laws have included regulations to stop individuals who threaten physical harm to others from misusing firearms. As applied to the facts here, Section 922 G8 fits within this tradition. The right to keep and bear arms is among the fundamental rights necessary to our system and of ordered liberty. The right, however, is not unlimited. And they're citing to Heller, and the fact that they're citing to that line again from Heller here in the majority opinion of Rahimi is not going to be good going down the road. I can tell you guys that right now. You're going to see that cited even more now. And then it says the reach of the Second Amendment is not limited only to those arms that were in existence at the founding. So again, that's also something kind of good for us. That's some good language there. Again, referencing Heller. And then it says, rather, it extends prima facie to all instruments that constitute bearable arms, even those that were not yet in existence. By that same logic, the Second Amendment permits more than just regulations identical to those existing in 1791. Under our precedent, the appropriate analysis involves considering whether the challenged regulation is consistent with the principles that underpin the nation's regulatory tradition. When firearms regulation is challenged under the Second Amendment, the government must show that the restriction is consistent with the nation's historical tradition of firearms regulation. A court must ascertain whether the new law is relevantly similar to those laws that our tradition is understood to permit, applying faithfully the balance struck by the founding generation to modern circumstances. Why and how the regulation burdens the right are central to this inquiry. As Bruen explained, a challenge regulation that does not precisely match its historical precursors still may be analogous enough to pass constitutional muster. Now I'm going to stop there because what they're primarily hitting on here is, at least what Justice Roberts is hitting on here in his majority, is when the en banc panel and when the 3-judge panel here in the Rahimi case analyzed this case under Bruen, they said that there was no historical twin. as required under Bruen, and therefore 922G8 failed. Now, here what Justice Roberts is saying is, in Bruen, they talked about, a dead ringer or a historical twin, could justify a regulation, but maybe you could draw analogs to other regulations. And essentially here, I guess giving a little credit to Roberts, and I don't really want to give it a lot of credit in this opinion. What he's talking about here is that you don't need a historical twin, you don't need a dead ringer regulation that the government has to prove. They can draw analogs, and there's a process in which they can kind of draw analogs to modern regulations or some other restrictions that historically existed to justify whatever restriction they're putting in place. And here they're arguing that as applied to Mr. Rahimi in his case, when this case was analyzed by the Fifth Circuit en banc panel, them relying and saying, hey, there's no historical twin, there's no dead ringer, therefore this fails, that was improper, that was not the correct type of analysis. Now, again, even just looking at some of that and hearing some of that language, you guys are probably saying, that does not sound good for the 2A cause. It does not sound, in some ways it's limited, but in other ways, I think there's going to be a lot of negative lines in here, a lot of negative language that's probably going to be used against us down the road, because we saw that already with a lot of dicta that was in Heller and Bruen. And now you have a majority opinion authored by Chief Justice Roberts, and probably a lot of other concurrences as we go through this, that will have some negative language that's probably going to be latched onto to justify various state restrictions and federal restrictions on the Second Amendment. So on part 4, you can see where they're talking about that analysis or the error of the Fifth Circuit, because they say the Fifth Circuit erred in reading Bruen to require a historical twin rather than a historical analog. The panel also misapplied the court's precedents when evaluating Rahimi's facial challenge. Rather than consider the circumstances in which Section 922G8 was most likely to be constitutional, the panel instead focused on hypothetical scenarios where the provisions might raise constitutional concerns. Finally, the court rejects the government's contention that Rahimi may be disarmed simply because he is not responsible. The court used this term in Heller and Bruen to describe the class of citizens who undoubtedly enjoyed the Second Amendment right. Those decisions, however, did not define the term and say nothing about the status of citizens who were not responsible. So that was one of those arguments that was being made by the federal government, where they were saying if someone is not responsible or not a responsible citizen, they could be stripped of their Second Amendment rights. Here, at least the court is expressly rejecting that. They're saying that language there that was pulled from Heller, where they talk about a law-abiding responsible citizen. They're saying, they didn't say anything in Heller about who is not responsible and who could be stripped of Second Amendment rights. They're saying here the government's reliance on the whole responsibleness is invalid, and they're rejecting that. So again, that's something semi-good in here, but I'm already seeing some language that I'm not a big fan of. Again, going to be going through this more comprehensively and definitely putting out a more comprehensive video. And we're going to see how this goes forward, applying to other cases, other issues. But again, 8-1 decision in favor of the federal government against Mr. Rahimi, finding that 922G8 as applied to Mr. Rahimi is not unconstitutional, or it's constitutional, however you want to put it. So essentially 8-1 in the federal government's favor. The only dissenter was Justice Thomas, and that should signal a lot to you guys what's going on here. So again, keep an eye out for my later video where I'm going to break this down even more comprehensively. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by Armed Scholars, and this nation will be maintained by Armed Scholars.